Right. Good afternoon, everybody. My name is Jeff Smith. I am one of the shareholders here at Altitude Community Law. We are going to be going over mediation, arbitration, litigation. What's the difference and why do we care? Thank you guys for joining us. On your screen, you should primarily be seeing the PowerPoint presentation. You should additionally be seeing a small box on the left-hand side of the screen with the presenter, myself. On the right side of the menu, you will see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting. If you have audio or video issues during the presentation, please click the No Audio or Video button below the PowerPoint on your screen and follow the instructions. One CMCA credit certificate will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. These credits are not transferable. Please save the image of the certificate that is in the body of the email if you wish to preserve the image. To save the certificate, right-click on the image in the email and save it as a photo. The image of the certificate in the email will only be available for 30 days, or print the email with the certificate. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. Lastly, there will be a survey that will pop up at the end of the webinar. We truly appreciate any feedback you can provide. Your thoughts and opinions assist us with improving our future presentations, so please don't hold back. All right, now with the housekeeping taken over, let's go into this webinar. Like I said, this is going to be about mediation, arbitration, litigation. We're going to be kind of talking about what the differences are between those, so you have a general understanding of what takes place in each, and then talk about kind of some strategies on how to determine which would be our best venue and how to keep the costs as low as possible, although sometimes we cannot do that. So again, we're gonna focus on what factors are important in determining whether to go to litigation. And when we're talking about litigation, we're talking about things typically other than your covenant enforcement or your collections cases. These are really cases where maybe we're having to sue the vendor, maybe it's a landscaper or snow removal company. Maybe someone is suing the association for saying the managers or the board members didn't produce documents or anything along those lines. We're talking about that type of litigation, not so much your covenant enforcement and collection, because they run a pretty simple process where we kind of go the same steps over and over. These ones are a little bit different. We'll also be talking kind of about an evaluation in response to threats of litigation, how you go about doing that, and some tactics to manage litigation and save money. All right, so we'll start off first with mediation. What is mediation? Most of the managers probably have been to a mediation, either in a collection or a debt recovery setting. The setting in a bigger case is going to be similar. It just will be a little bit more detailed. Mediation is simply having both parties or all the parties come together with a neutral third party there who's trying to facilitate some type of a resolution. You can have mandatory or voluntary mediation. If an owner reaches out ahead of time before any litigation has been filed, we may recommend that voluntary mediation takes place. A lot of the different cities and counties will have mediation programs where you can try and get the parties resolved there. Sometimes if it's a neighbor-to-neighbor dispute, we'll advise that they should try and go do voluntary mediation. If a lawsuit has been filed, most courts will require a mandatory mediation. And so that's all it's saying, is that there's a court order requiring us to go there. Binding versus non-binding. So most mediation is going to be non-binding. I can pretty much guarantee you any mediation you're going to do in an HOA setting is going to be non-binding. All that means is that when we go there, a resolution doesn't have to be reached. If a resolution is reached, then a document will be filled out at the end of the mediation and signed by those parties. Once it's signed, then it becomes a binding contract. Up until that point, it's non-binding. So anything that is said at a mediation, anything that's disclosed, none of that can be used at a trial. We want to make sure, the reason for that being that we want parties to discuss openly without the fear of having something they said be held against them, because what we're trying to do is reach a resolution. Mediation in general is going to be relatively inexpensive. It's a complex case and we're having to do a day-long mediation. That could be expensive. But as you guys know, in the kind of collections, covenant enforcement side of it, It's pretty cheap. They're usually only going to be about 2 hours, maybe a half day. And most of the mediators are relatively cheap. Sometimes if we're having to use one of the big companies, those can be a little more expensive if we need a retired judge or someone like that to be the mediator. But typically the cost of the mediation is relatively low. When we're selecting a mediator, again, it's going to depend on what type of case it is. Ideally, we want someone that has HOA experience, or at the very least real estate experience. If it's a construction issue, we're going to want someone that might have some construction defect experience, things along those lines. So when we are recommending mediators, both sides will kind of look at what the facts of the case are, et cetera, what the issues are, and they're going to each propose who they think would be a good mediator. The other side will then kind of investigate that, see if that makes sense, and assuming we can both agree to one person, that's who we're going to choose to go with. Arbitration. So arbitration is different from mediation. Typically, the biggest difference is it's going to be binding. So arbitration basically is going to be a mini trial. And a lot of your governing documents will state that you have to go to arbitration for specific things. I personally would rather always be in court than arbitration. I don't find it to be any cheaper than arbitration or than court. I actually find it to be more expensive because you're also having to pay the arbiter. When you are in court, obviously the tax dollars pay for the judge. All of the same costs basically are still there for an arbitration as they are with a trial. And so I would almost always rather have a court. There are some times, and it happens a lot with like construction defect, where arbitration might make sense because that individual or group of three or how many arbiters there are, they might have specific expertise in construction defect. So in those cases, it might make more sense. But typically in a general HOA that's not construction defect, arbitration is typically more expensive. And again, the arbiters will make a final decision, and that decision is binding. In a mediation, there's no final decision. It's just a matter of do the parties come to an agreement or don't come to an agreement. And that's the big difference, is that in mediation, the mediator's trying to get the parties to come to a resolution. In arbitration, the arbiter is actually deciding who's right and who's wrong. So that is kind of the important part. Again, mandatory. Some of your governing documents will discuss if it's mandatory or not, or what claims are mandatory and which ones aren't. You don't see a whole lot of voluntary arbitration, not in our setting at least. Again, it is binding. Cost is going to be more expensive. Selecting arbiters is much more important than selecting mediators. Mediators in general, for the most part, most of the stuff that we're dealing with are contract disputes, so most mediators can handle it. If there's some specific facts, obviously we're going to try and dive down into that more. Arbiters, because they are actually going to make the decision, we spend a lot more time making sure that it's the right arbiter who is going to be appointed, because that can change everything. So that is much more important and more time exhaustive in an arbitration process than in the mediation process. All right, deciding whether to pursue litigation. Is litigation necessary or unavoidable? Is it important or beneficial for a community? Is the positive outcome predictable or attainable? Is the process manageable and controllable? Have you conducted a risk-benefit analysis? Have you conducted a cost-benefit analysis? So all of these questions, especially when we are talking about we're going to go sue the grounds crew because we think they only came out twice this month, not 4 times. We want to get rid of our contract. We don't want it to pay any penalties, etc. Before you decide to go to litigation, you're going to want to, one, discuss this with the board. Go through kind of this little checklist of is it necessary? Is it beneficial to the community? What do we think the outcome's going to be, etc. And make sure the board is agreeable that litigation makes sense. Then you're going to want to turn it over to the attorney. The attorney's going to want to look through the information and also got to go through the same checklist and help explain whether or not we think that the association has a good case, what the process is going to look like, give you kind of the risk-benefit analysis of here are the good parts of the contract, here are the bad parts of the contract, cost-benefit analysis in terms of here's what it's likely to cost, here is if we do win, here's what we gain by doing it, here are the risks. If we lose, do we have to pay the other side's attorney's fees, etc. So this is just kind of your basic checklist of things to be thinking about when a board is trying to decide, do we want to move forward with suing someone? So when we're looking at this list, or that list on the page before, we want to try and get out of the weeds. We don't care. It's not so much that we don't care about the factual issues. We want to think about big picture. So we want to not get stuck in the trees, but look at the forest. So we want to focus on the issues, not the personalities. I mean, the amount of times that we end up in lawsuits because we think the other side is mean or being a jerk or something along those lines is incredible. We want to try and remove the personalities from that. Second, we want to make sure it's in the community's best interest. We don't want to spend $30,000 on attorney's fees that we might not be able to recover to get out of a $3,000 contract usually. So you're always going to want to be looking at what's in the community's best interest. Is it really, maybe the contract's only going to last for another 3 months and then the contract ends, the growing season's over, and we can pick a new landscaper next year. In that scenario, it might not make sense for us to move forward with a lawsuit. Impact on ongoing relational interests. Do we really want to sue a vendor over something small if we've had a generally good experience with them? We all know how hard it is to find good vendors. So does proceeding with litigation, is that going to ruin our ability to work with these people in the future? Obviously, in most cases, yes. Normally, people don't want to work with someone who just sued them. Impact on litigation on property sales and refinances. Oftentimes with construction defect claims and things along those lines, there might be a lien, or maybe there's a mechanics lien that's put on the property. And so that can affect people from being able to sell their units or refinance their units. So that's obviously something we want to look at. We're always looking at insurance issues. Does the association have insurance for this? Or is the company that we're suing, do they have insurance? So there's another pool of money to hopefully resolve this issue. And then indemnity issues. You guys see this the most when an owner sues the association. They name you. In most of your management contracts, there's going to be some type of an indemnity provision. And so ultimately an indemnity provision would say that if the lawsuit goes to trial and the court determines that the management company did something wrong, or the party that's indemnified did something wrong, the association would then have to arguably pay for those damages. There's a difference between a duty to defend and an indemnity provision. Duty to defend, you'll see more in an insurance contract where the insurance company might not be responsible for paying damages, but they might have a duty to hire an attorney and defend the case for the association. Vice versa on indemnity, the association might not have a responsibility to pay for the defense of the management company, but they might be responsible for the damages, or it might be both. So all those provisions are going to be something you have to look at on a case-by-case basis. So consider strategies to prevent, avoid, and minimize litigation. So awareness, education, communication, dispute resolution policies, covenant enforcement policy, collection policy, etc. So ultimately, the biggest way to try and minimize litigation is awareness. Making sure that you are aware of what's going on in the community, the concerns of the board members, the concerns of homeowners. If we're getting a bunch of complaints about snow removal or landscaping, things along those lines, addressing those concerns before you get to the point of litigation is the easiest way to minimize. So if we've received 4 complaints about the trees not being trimmed properly and we haven't talked about it at a board meeting, or we haven't addressed it with the landscaper, that's problematic. Ideally, when we get these complaints, we want to make sure we get them to the board so that they're aware of them. And then we want to try and address them if the board agrees that there's an issue. That is the single best way to try and limit litigation. It's not going to work all the time, but it certainly is helpful, and it certainly is beneficial to members of the association if they believe that the board is taking their concerns seriously and trying to address them. I know it never moves fast enough for the membership and things along those lines, but if we can talk about, this is what we did this month, we got this complaint, this is what we did to try and address it, and that's out there, that is typically very beneficial. Education, again, you have the obligation to provide some education at the annual meeting. So putting out things on covenant enforcement, putting out printing off an article from our website that talks about litigation or talks about covenant enforcement, or this year for the last 3 years, the updated collection policies, things along those lines. Providing education to the board and the membership as to what is going on is always beneficial. Communication, again, goes along with awareness. First, obviously, we have to be aware of the problem. Then, ideally, we do a good job communicating with the community as to what we're doing to try and resolve these issues. Again, this is not in terms of a collection issue or a covenant enforcement issue. This is talking about bigger issues. We don't want to be communicating with the general membership about individual properties or people who are behind on their dues, things about that. But if we're talking about snow removal or landscaping on the common elements, things like that, we want to make sure we're providing a lot of communication. Dispute resolution policy, depending on when yours was drafted and who it was drafted by, sometimes you'll have language inside the declaration that we'll discuss about, that will discuss kind of the process. We also are going to have a dispute resolution or ADR policy. Some of those policies are just simply say, look, we encourage that homeowners come and talk to us if they have an issue before they file litigation. Sometimes it'll say there's a process where before an owner can file a lawsuit, they first have to provide us with a written complaint, and then we have the opportunity to go to mediation, something along those lines. All the policies and language in the governing documents are slightly different, so you got to make sure for each association you're aware of what those policies are and what those procedures are, and make sure we're following them. Obviously, with the covenant enforcement and collection side, we deal with those policies all the time as vendors of the association, so you as managers are probably pretty well informed about each of the policies and making sure that we followed all the necessary steps before we can move forward with litigation. Evaluation and response to threats of litigation. So one of the best ways are your human resources. So board members, managers, developers, owners, vendors, legal counsel. If a complaint is coming in or if a lawsuit has been filed, the first kind of step is we want to make sure we understand all the facts. Were board members being emailed outside of the managers? So is there communications that the managers are not aware of that we're going straight to the board members that need to get churned over to legal counsel so that they can review the whole situation? Vice versa, is there stuff that's been sent to the managers that the board members are not aware of? Are we dealing with developers? Is this something that hasn't been churned over yet, so it might be something easier to resolve with the developer? All of those things are going to come into place, and we all have relationships with different individuals in the association. So if we have a good relationship, we might be able to work this out without having to go through litigation. Next thing when we're evaluating is we want to make sure we understand the goals of the community. What is the end result that the association is looking for? Are we trying to get in a new vendor because we're not happy with this one? Are we generally happy with this one and we are trying to work out something that is more favorable to the association in terms of money or the quality of work that's being done? So those things we always want to make sure we're going into a lawsuit with a specific goal as to what it is. And obviously with collections, it's the association needs its money. With covenant enforcement, it's that, look, we need the property to come back into compliance. The other ones are sometimes more difficult, as maybe the contractor put in a pool and we don't think they did a good job, or whatever it is. We want to make sure we understand the goals of the community and how we can best get there. Obviously, we have to review the applicable governing documents, see what in there is applicable. If it's a third-party contract, then there might be very limited review of the governing documents. It might not be nearly as important. If it is an owner suing the association for failure to comply with the governing documents or breach of fiduciary duty, something along those lines, then the governing documents are going to be very important. So it just kind of depends. As attorneys, we certainly want to make sure we are provided with all of the related documents in history. There's nothing worse than getting into the discovery stage and you've been told something by the board and by the association managers that this is what's happened, this is just this owner being ornery, there's really nothing to this, blah, blah, blah. And then we get discovery from the other side, and there's all these emails that we've never seen where a board member is saying things that are inappropriate or bad to our case, or all those things. We want to have those on the front end so that we can help develop a plan, minimize whatever those issues are that might have been written down, and also help the association determine, look, maybe we want to resolve this early on the front end because we have some really bad facts. Once we're in the discovery stage, or we've spent thousands of dollars going through this process, and now we get these things, it's a much harder time to try and resolve the issues. So again, we always want all of the information up front. It certainly will help us in the long run. Were required policies followed? This is a big one, especially with how the HOA industry is viewed in the courts right now, especially if you're dealing with something in Arapahoe County. They're probably the worst right now, but courts are always looking for a way, especially if it's a homeowner who's suing the association, to find that the association did something wrong. And so if we haven't followed our policies, and oftentimes if we're suing an owner, we're saying, look, they failed to comply with the governing documents. If the owner can then turn around and say, yes, maybe I did fail to comply with the governing documents, but so did the association, that's problematic to us. The court is always going to jump over us, all over on us for that. And typically, if we haven't followed the policies properly, we're never going to get attorney's fees. And so that is problematic for the association because they've been paying my firm or whatever firm they're using the attorney's fees the whole way, with the expectation in most of these cases that they're going to recover some or all of those attorney's fees. If a policy wasn't followed by the management company or by the association, and the court ultimately might rule in favor of the association, saying the owner has to do X, Y, Z, but because you didn't follow these policies, you're not going to get any of your attorney's fees. The association obviously is going to be very frustrated if they're still paying a $5,000, $10,000 bill simply because the policies weren't followed. And then obviously you want an unbiased factual and legal review. That's really the benefit of turning it over to the attorney. You guys deal with these owners and these vendors day-to-day basis. For me, it's just another file that's come through. I don't care about the personalities. I've never met these people. I have no preset idea as to what is going on. And so when you turn it over to me, I'm simply looking at the facts in your governing documents and trying to determine for you whether or not you have a good case and is this something we should be going forward with. So that's obviously a key part of this. All right, evaluation response, hierarchy of authority. So oftentimes we get the board turning something over to us and they might not even care really what the issue is. Maybe they built a shed, but they didn't get the ARC first. And they're constantly harping on the fact that they didn't follow the rules. And that's really an emotional response. It's not that what they're doing is actually violating the governing documents. It's that they didn't follow the process that we've set up. And so while obviously the process is important, we got to take emotion out of this. So in terms of hierarchy, the most important thing obviously is the law. So this is going to include the Constitution, statutes, case law, things along those lines. That's going to be your overarching thing. So Kiowa, the nonprofit code, if it happens to be a HOA case that has case law similar to it, that's always important. The Constitution doesn't come up all that often. Metro districts, it will. So for some of you guys who represent metro districts, the Constitution comes up from time to time there. If it's a discrimination claim, Constitution might come up there. But typically we're talking about Kiowa and the nonprofit code. Next is going to be your governing documents. So obviously your declaration, your bylaws, your articles, all of your policies, etc. So it's going to go law, then the governing documents, then the facts of the case. So when we're next evaluating, we now know what the law is. We've reviewed the governing documents. Here's the actual facts. And so now we have to apply those facts to the law and the governing documents. That's kind of the evaluation process that we're going through. After that, it's opinions and emotions. And to be honest with you, unless the opinion is coming from an expert, which sometimes we have to get expert testimony, opinions of the board members, opinions of the manager, my own personal opinions typically are not all that important. Similarly with emotions, we don't particularly care how this makes you feel, how hurt you are that they're not willing to follow or they're not validating the time that you put in or the time that the board puts in. Those things don't, from a legal standpoint, carry any weight. And so often when we are prepping for trial and we're talking about getting on the stand, we don't want to hear about your emotions. We don't really want to hear about your opinions. What you are there to do is to be a fact witness. We want you to tell us exactly what happened, tell us what the governing documents say, and then the court will determine whether or not we're right or wrong. But the top three things, they're the big important part: law, governing documents, facts. Opinions and motions, again, aren't overly important or persuasive. So again, just kind of elaborating on this. So the constitutional protections, again, unless we're in front of the Colorado Civil Rights Division, or unless you're a metro district that is governmental, the Constitution likely is not going to come in. There may be some claims that are here and there, but it's typically not going to happen. Federal statutes, again, typically aren't going to come into play for HOAs unless we're talking about discrimination type claims. Or we're talking about, still kind of tied to discrimination, but the Fair Housing Act. State statutes, again, Kiowa, nonprofit code, those are the big ones. Occasionally, the old Condominium Act will come in, depending on what we're dealing with. Maybe they'll be making common law arguments or some type of breach of contract type claims that are outside of Kiowa, but that's relatively uncommon as well. Covenants and plats, one thing that we forget about a lot is that on the plat maps, and plat maps are considered part of the declaration, but oftentimes on those plat maps, there are dedications and there are restrictions that are on there. And oftentimes we don't look at those things, or we're not as aware of those because we don't see them quite on a day-to-day basis like we do the CC&Rs. So one thing to remember, especially if we're dealing something with roads or we're dealing with lot line issues or boundary issues, those plat maps, or fencing issues, comes a lot with fencing. Plat maps, ODPs, things like that, they might have additional restrictions that we're not used to seeing. So it's another place to go look. Articles of incorporation rarely come up in anything that we do. Bylaws obviously come up a lot. If someone is questioning whether or not a meeting was called properly, or if someone is questioning, how can I remove a board member? How can I call a special meeting? Is this person qualified to serve on the board? Those types of things, bylaws come up a lot through that. Rules and regulations, so again, when we're talking hierarchy, it's going to go Constitution, then federal statutes, then state statutes, then your CC&R/plats. Then articles, incorporation, and bylaws are seen kind of at the same level. And then below that is going to be rules and regulations, and your mandatory Kiowa policies. And so the rules and regulations, why they're going to sit below the covenants and plats, is because it's the board that creates these rules and regulations. The covenants, if we want to amend them, obviously the owners have to approve it. Rules and regulations, there's not going to be ownership approval, and so that's why they don't receive the same kind of hierarchy of authority from a court. They're still going to apply them as long as they're reasonable and there's grounds for them in CC&Rs, but they don't carry that same weight. Same thing with the mandatory Kiowa policies. Because they are getting based off of state statute, as long as they comply with the state statute, the court is going to apply them. But obviously there are differences that can happen in each policy, and if you are putting something in the policy that is in addition to the state statute, it's not going to carry the same weight. All right, evaluation and response, so facts. So laws and documents remain the same. It's the provable facts that are going to be the determining factor. And as with anything, it's the devil's in the details. And so each case is going to be unique. There is no case that's exactly the same. There are going to be, in every case, there's going to be some good facts for the association. There's probably going to be some bad facts for the association. And that's why we are so adamant that we want everything up front. I know it seems silly sometimes that we want every communication that's been sent with this owner, whether you think it's relevant to the case or not. But we want to go through there and make sure there's not pitfalls that are going to surprise us at the case. If we know them on the front end, we typically can develop strategies to either minimize that or completely knock those things out. But if we're getting them sprung on us late in the game, it makes it much more difficult. I was recently doing like a pool case where we were going after the pool vendor, and the issue was talking about filters that the pool vendor had said they had ordered, but that the order came in and it was the wrong size pool filter. Well, we got into depositions and we were actually able to get the other side to say, look, basically we lied. They were never actually ordered. They were never delivered in the wrong size. We just never ordered them. And that was sprung on opposing counsel that day at depositions. And because of that fact coming out during the deposition, the case settled within a couple weeks after that. And so having those things sprung on you in a deposition or in a trial is worst case scenario for the client and worst case scenario for the attorneys. We always want to make sure we have those things. We want to be able, for us to evaluate the association's case properly, we need all of that on the front end. Again, we don't want the association spending good money after bad. And so if this is a case where the facts are bad for us for whatever reason, we might need to settle early on. We don't want to spend a bunch of attorney's fees if we're going to end up settling in the long run anyways. So those are all things that we want to look at, what we want to decide. Obviously, we're going to be looking at, is the law favorable? Are the documents favorable? Are the facts favorable? Some of the things that are very important to us as well is, are we going to have good witnesses? So when I am getting ready to try a case, I want to, ideally, I've been talking to the board numerous times, and we're talking, again, bigger cases, but I've talked to the board numerous times. I have a decent understanding of who has the most knowledgeable on facts, who's the most even demeanor, who's not going to get emotional on the stand. Those are the people that we want to call. Same for you guys when you are managers and you are going to be our witnesses. We want you to be even demeanor. We're not looking for your opinions. We simply want the facts. We don't want you to get emotional on the stand. We simply just want you to answer the questions. And when you're getting cross-examined, it's hard because you feel like you're being attacked. You feel like the other side is saying you did something wrong, etc. And it's very easy to get defensive. So we're always trying to make sure we find the witnesses that are most favorable to the association, just like we will the facts. So that is a big thing. Also, if the association is suing someone, we are wanting to make sure that there's insurance on the other side. We want to make sure if we go through all this effort, we get a judgment that the association is going to get paid. Same way when someone's suing us. They know that associations have insurance. They know there's an extra pool of funds out there. And so availability insurance is always a big deal. It leads to a lot of settlements when insurance is involved because you've been paying these deductibles, these premiums, and then your deductible with the expectation that the insurance company is going to step in the best interest of the association. And oftentimes that's how things get settled. So consistency versus situational decision-making. Again, the reason why we have so many policies, one, because they're state mandated, but also in terms of just the associations, we want consistency. You hear it from us in any class that we talk about in terms of covenant enforcement or collections. We want to treat everyone the same. And if you follow your policy, in theory, you're treating everyone the same. When we're dealing with situational decision-making or discretionary decision-making, that's where things can become a little more problematic when we've made an exception for this person, or the reason this person's having all these violations because they live next to a board member, not because of the manager seeing these violations or things like that. That's always a problem. If I'm seeing a bunch of situational or discretionary decision-making going on, that's going to be a bit of a red flag for me and something that I'm going to want to address with the board on the front end to explain to them, like, look, here are the problems. This could be problematic. Even if your decision might have been right, why did you come to it? Things along those lines. Cost-benefit analysis, again, this is relatively simple in terms of what's it going to cost for us to actually win this case? And if we win this case, is it a benefit to the association even at the cost? And most of the time, the answer to that is yes, especially when we're dealing with debt recovery or with covenant enforcement. But again, as we talked about briefly at the beginning of this, when we're talking about a contract that maybe only has 3 months left on it, it might not make sense to go through a bunch of effort and spend a bunch of attorney's fees to go through litigation. If we are talking about, say, a garbage contract that auto-renewed 2 months ago and we missed our time frame, but we want to get out of this contract because we're going to be in it for the next 5 years, in that scenario, it probably makes sense for us to try and push it. But those are things that we're going to be looking at. Obviously, Is there an attorney fee provision in the contract? Things along those lines. Risk benefit, again, this is looking at kind of more of the worst case scenario. Let's say we go through the trial. Our facts are pretty good, but it's not a slam dunk. We think we're going to win. Court comes out, court rules against us. Not only are we on the hook for our own attorney's fees, we're now on the hook for the other attorney's fees. Maybe there's additional damages. So we want to make sure that the board is aware of what those risks are going into it. There's nothing worse than getting 4 months down the road, or the association's already spent $5,000 on litigation, and all of a sudden they feel blindsided because they think that they had a slam dunk case, that there's no way you're going to lose, etc. And just now they're being informed of the risks. We want to make sure that they're aware of the risks on the front end, and make sure that they are going eyes wide open into any type of litigation. So again, with any kind of decision making that you're making, you always want to take a step back and make sure you're looking at the facts objectively. So it's always a good thing anytime you're making any type of decision, but especially if we're making a decision going into litigation, that we take a step back, try and see the arguments from both sides, and make our best determination that we can. In terms of the right people, this kind of goes back to good witnesses as well. But if we have a overzealous board or an overzealous board member who is dominating the rest of the board, kind of running their own agenda, doesn't seem to be following the rules, things like that, that could be problematic. That could be a reason that we want to settle a case early. So all of these things, again, go into the analysis. So tactics to manage litigation and save money. Planning is a big one. So again, before we file the lawsuit, making sure we have a risk assessment, cost assessment. Those two things are obviously, they're probably kind of the easier things to judge in terms of, look, we can give you a range of what we think the cost is going to be. Do we need experts, which are going to drastically raise the price? Is this not going to be something that requires experts? Do we think there's going to be depositions? Things along those lines. Risk assessment, hey, here are the good clauses of the contract for us. Here are the bad clauses. Those things are relatively easy, but they're good things to look at ahead of time to make sure you're making the right decision. People management, are we going to appoint one person to be the liaison with the attorney? Are we going to have one board member? Are we going to just have the manager? Who's doing that? If we have a bunch of people who are asking similar questions to us, obviously attorney's fees go up in that case. So having kind of a streamlined process for that is always good. Money management, does the association have the ability to pay for this? Can they front this money? That's obviously something that, or do we need to do a special assessment off the bat? Are there different things that we have to do to make sure the association's in its best position to be successful once we get to trial? And then insurance issues, again, is insurance going to cover if we're being sued? Is this a claim that is covered? Is it a claim that isn't covered? All of those types of things go into that planning stage, ideally before we file any type of a lawsuit. Some more tactics, managing kind of the process. So early on, what's our strategic goal? What's the end result that we're looking for? And what's our plan to actually get to those goals? So are we looking just to apply pressure to the other side so we can reach a favorable settlement? Is the board really wanting to go all the way to trial? Is the goal that we want to get this house because it's a foreclosure? We want these people out of the community. What is the actual goal that we're looking for? Oftentimes we get things from the board and they're just like, we're just unhappy. And that's not really a great goal. We gotta figure out what the actual goal is and what's our best approach to get there. And then we got to create those strategies, put those in place as to how are we going to get to this goal. Is that talking about, hey, before we file litigation, let's have you manager or you board member reach out in writing in an email to the contractor saying, hey, here are the issues that we've seen. We've sent you other emails on X date, blah, blah, blah. You haven't done anything to fix these. So we can help create a record of what it is we want to be able to prove at trial. So we might ask a board member to do that or the manager to do that. Sometimes that'll happen, especially if it's a long-term contract kind of thing and they've been there for a while and we've had issues with them and we want to get out of the contract. We oftentimes will want to get stuff in writing to them and see if they'll respond. Maybe they will say, yes, I'm sorry, we agree, this has happened, but we have plans to fix it going forward. And maybe we'll tell you at that stage, all right, give them a month, see if it fixes it. If it doesn't, great. We have them admitting that they did have issues. We gave them a chance to rectify those issues, and they haven't done it. That obviously would strengthen our case. So those kind of strategies will come up from time to time. Organizing, this is obviously huge for both board members and you guys as managers. Making sure we have a clear record, making sure we have any text messages that were sent, all the emails that are saved. If you're having a phone conversation with a vendor and they're saying XYZ, that you sent some type of an email to the board saying, I talked to the vendor today. They said they're going to be out on this day, blah, blah. Trying to create a timeline, trying to have those things, documentation, real-time documentation of what's going on is always key. And it's just a best practice regardless whether there's an issue or not. But making sure you're documenting what you're doing through the day for the association is always a important part. Budgeting, again, it's always smart for a manager and or association to kind of request an initial budget as to what this lawsuit's going to cost. What are the steps? What's the cost, do you think, before we get to a lawsuit? What's the cost from the lawsuit to the discovery stage? What's the cost from the discovery stage to the trial stage? And then ask for updates. There's nothing wrong with, and we certainly welcome it, anytime a board or manager is asking us kind of for those budgetary type questions. You certainly should do that and try and, if the attorney is going outside of what that budget is, make sure you're asking them why and what the reasoning is. Those are always good things to help keep the costs under control. And again, this is really talking more about big type litigation, not your general collections, covenant enforcement. I mean, those are kind of standard ages unless there's standard ranges, unless something crazy has happened. But when you're talking about a big full-scale litigation that's going on, if we're going to have experts, that's right there going to probably add $15,000 to the bill at least. If we're going to have multiple experts, you're going to be multiplying that. If there's going to be a bunch of depositions, that's going to drastically raise the cost. Whether we're taking the depositions or whether we're defending the depositions, that's a lot of money to prep for those and do them. So having that general understanding of what this is going to cost is definitely helpful. And budgets obviously are flexible and they're going to be ranges. Attorney can't give you exact numbers, but they can give you decent ranges of what's going on. Choosing, directing the team. Again, ideally we're going to, the manager, the board, the attorney, we're all acting as a team. And if we bring in experts, they're acting as a team. We want to make sure that we're choosing the right people, directing, making sure they're getting the direction that they need, making sure information is flowing between all members of the team. That's all very helpful. And then obviously a reality practicality check, checking in with the attorney at different stages as to, I mean, after discovery, is there something that came up here that you think changes your initial interpretation of this case? I mean, typically the attorney is going to let you know when they see a fact that they think is bad or they see a fact that they think is very good. But constantly reassessing that is always beneficial to managing the process. Tactics to manage, again, managing the process. So discovery. Discovery can take place in a couple different ways. So discovery, what kind, how much, and at what cost. So the first part of discovery is kind of what the initial discovery. So that's your fact investigation, informal discovery. This is going to be making sure we have all the documents, everything on our side. So documents, maybe we need to interview some of the key players, any background research. The investigation is informal, as discovery can be. It should happen before filing a lawsuit. So typically, again, that's why we want all this information on the front side. This is the fastest, most efficient, and least expensive part of the discovery side. So this is just us making sure the case that we are about to file is going to be a good case. And that part is relatively fast, relatively cheap, not overly complicated. Then we get into formal discovery. That's once a lawsuit is filed. And this is going to be dictated by the court rules. So this may include interrogatories. So written interrogatories are a set of questions that we will write for the other side. They have to answer them. And they will object to different parts, and there'll be different things that are written. But Interrogatories are a formal written questions. We can also do formal record requests. There's limits to how many questions you can ask. There's limits to how many documents you can request. But one of the things we'll do is make document requests. Requests for admissions. So we will phrase questions basically in the form of admission. Admit that you failed to shovel the snow on December 24th. And they'll either admit or deny it. And so those are different things. Again, you have a limited amount of admissions, but those are written discovery that we would do. Sometimes we're going to have to go inspect the property or premises if this is a roof issue, if this is a common element issue, something along those lines. There might be an inspection of wherever it took place. If there are claims for a trip and fall or things like that, there might have to be an independent medical examination. Sometimes we're going to have to subpoena records from the other side, so that's just a court order saying you have to turn over these specific records. Sometimes we'll have to subpoena records from a third party. So maybe they had a subcontractor or something along those lines. We might need to get those. Maybe we know that an owner has been communicating with another owner in the community that is not a party to the case. So we might want to subpoena the records from that third party. Then we're going to have depositions of fact witnesses. So you as a manager might get deposed. The other side would say maybe they take a 4-hour deposition or however long the deposition is going to be. Typically, depositions are limited to 6 hours. And so we would go through that. They would get to ask all of their questions. If we're defending the deposition, we would be there to object to some questions, help you at breaks to clarify answers, things along those lines. On the flip side, we would be deposing parties as well. Then you have expert reports. So if there's some claim that water damage, water has come from the common elements and it's causing damage to a single family home, we might have to get experts out there to talk about the water tables, talk about the elevation, all of that sort of stuff to make sure that we've done whatever we're supposed to be doing. After the expert reports are submitted, each side will typically have an expert in cases that require experts. Then you're going to depose those experts so we can go over the reports and ask our questions about that. So all of these things add up to a lot of money. And typically this is only going to be happening in a district court case. But it's expensive. And so that's why the key part to all of this is that front end side. We want to make sure that we're putting the association in their best case scenario. And that's really all you can do. And then you go forward from there. So choice of forum, ways to save money. Again, informal board manager owner dialogue. It's always good to be having conversations with owners. We had a recent case where an owner had been complaining to the board. There was a fire. It had taken 18 months to fix the property, fix this individual's unit. And really they weren't actually even they weren't fixing this unit. They were needing to use this unit to get to the damage of a different unit. And there just was very little dialogue between the board and the owner. And that led to the owner filing a lawsuit. Had the board been able to converse with the owner a little more regularly, I think we would have avoided that and explained to them what was going on. And you're not always going to be able to avoid it, but it's certainly beneficial to have that communication. Again, board meetings, architectural meetings, communication is key. Making sure that we have the required Kiowa policies and are following them. The amount of times that a plaintiff's attorney will throw in some random claim regarding the association not following specific policies just so that they can get attorney's fees it happens a lot. So if you have policies, make sure when you have the policies, make sure you're following them. There's a reason why you have them. If someone requests a hearing before the board or the ACC, we should grant those. If you have any questions, reach out to your attorney, but almost always the attorney is going to say yes. If an owner wants to come speak to the board or the ACC, you should allow that. Sometimes you're going to have administrative hearings, CCRD, zoning, land use, building code process. They can help resolve issues sometimes. Administrative hearings are typically going to be a little bit cheaper than court, but it'll change from time to time depending on the issue. Again, mediation is the cheapest way. Arbitration and lawsuit are similar costs. Again, always be circling back on your strategies. This isn't stagnant. It's fluid. With each fact that comes out, which each disclosure that is given, the facts change. So circling back on strategies and making sure we're keeping up on things is key. Sometimes we might ask for a stay. So maybe a lawsuit's been filed. We might ask the court to put something on hold so that we can try and have a negotiation or a mediation or informal discovery to try and keep the cost lower while still resolving the case. Typically, we're going to ask for a stay if we think that there's problems with the case and we want to get it resolved quickly. All right, so timing considerations. Sometimes we have to go get a immediate result, so like a temporary protection order or a temporary injunction. That might be maybe someone is building something on the common elements, and we need a court to stop them immediately, and then they'll put a temporary hold on there. We'll go through the process so that they can't continue to damage the property. So sometimes we have to do that. Sometimes we are on the flip side, so it's not on the front end, it's on the back end. They built a shed a year ago. We only have a year from when they built it to file the lawsuit. So we got to make sure that we're paying attention to the statute of limitations. So those two things come in from timing considerations. Cost considerations, does the association have the money to fight this? Is it best for the association, even though they might be right, to pay a couple $1,000s rather than try and defend this for $20,000? What's the evidence say? Obviously, that's one of the biggest ones. We're always going to be looking at the evidentiary considerations. We talked briefly about kind of the meeting, hearing, mediation. Again, always communication is key. Small claims court, typically attorneys are frowned upon there. It's supposed to be kind of individuals, not attorney related. But if the association is getting sued in small claims court, they have the ability to be defended by an attorney. So we sometimes step in there. Small claims court is relatively cheap, but the downside is oftentimes you're not going to recover the attorney's fees. County court is where the vast majority of litigation that association sees takes place, because that's where all of your collections and all of your covenant enforcement will happen there. It's relatively cheap. You're usually talking less than $10,000 in attorney's fees in a county court. Obviously, some cases can blow that out of the water, but the vast majority of time, it's relatively cheap. District court is much more expensive. The rules are much more cumbersome. This is where we get into the real discovery. I mean, attorney's fees can be $50,000. They can be a couple $100,000. They can be a couple million, depending on what the case is. So that's where you see big attorney's fees, is in district court. Receivership, you will see in foreclosure. Receivership oftentimes comes in when we're doing a foreclosure. If the property is vacant or if the property is rented, we will ask the court to appoint a receiver who will step in the shoes of the owner and will basically, their job is to maintain the status quo of the property. So the receiver will come in there. If the association is owed money, the receiver might be able to take those rented funds, and first they'll pay themselves, but then they can pay the association to help lower a judgment amount. So we see those in foreclosure a lot. We see them in high value collection cases. And then you have bankruptcy, which is the worst case scenario for everybody. You spend a bunch of money, you're going through the litigation process, maybe we're about to foreclose, and the owner or entity files a bankruptcy, which puts everything on hold. And now the association might not get any money. The association might have to wait 5 to 7 years to get money. So all these different forms come into play. So again, main things to be paying attention to. So play an active role. Make sure the board and the association are planning. They're talking with their attorneys. They understand what the plan is. Make sure you are keeping good records, good fact development. Request and expect status reports. If you're not getting status reports on a big case, make sure that you're getting them. Make sure you ask them. There's nothing wrong with making sure that you guys are completely up to date. I know with like collections and covenant enforcement, we have the status reports you can pull each month, and that's fine. But if you're dealing with a real litigation case, you want to make sure that you're getting updates on a regular basis. And that might, again, there might be times where it's going to be 4 or 5 months before something relative happens. But you should know that that's going to be the process, and that you should be expecting an update around that time. Always be considering modifications and adjustments to the goals based on the developments of the case. Ask questions and don't feel afraid to provide any ideas to counsel. So attorney's fees, this is one of the biggest driving things. What are the prospects for recovering the attorney's fees? Is there a statute that will allow you to recover it? Is it in the contract? Governing documents, obviously, almost always will have that in there. What are the risks for paying the other side's attorney's fees? If we lose, do we have to pay them, etc.? We talked about insurance a bunch. Making sure, obviously, the declaration, Kiowa, all of that, we want to make sure as much as possible is on our side. So again, the prep work is the key to litigation. If you get nothing else out of this, make sure you're documenting things. You guys do this so often, you know when problems are coming, and make sure when those problems are coming up that you are being extra attentive to creating the record. Every time you call them, every time you spoke with someone, etc. Document that, whether it's an email back to them or it's an email to the board giving an update, etc. Those are all very key. All right, we got about 5 minutes. There's a couple questions. Let's see, first question. The decks have a section on ADR, agreement to avoid litigation. Declarant, the association is okay, this is like, all right, so there's a question basically saying we have an ADR provision. This ADR provision looks like it's saying that you have to go through, before you can file a lawsuit, you need to reach out to the opposing party and have some type of a mediation or an ADR. So not all associations have that. And oftentimes when you look at it, not all claims are covered in that. So depending on what the claim is, that section may or may not apply. If an owner files a lawsuit without going through this process, and the lawsuit is about claims that would be covered under the ADR policy, what we will typically do is file a motion to dismiss that claim. The court will do one of two things. The court will either say that, look, we agree, this is what they were supposed to do. However, all that has to happen is a mediation can take place. So we'll put this on stay. You guys do a mediation. If you don't resolve it, we'll continue on with the case. The other option that a court can do is they might dismiss the case. The owner at that stage can then go through the proper process and then refile their case. It's not going to be typically a situation where the judge will say, look, nothing's been done. They didn't follow this proper process, therefore they can't bring a claim. Typically, they're going to give the individual an opportunity to rectify that. Hopefully that answered your question, Kyle. Next question, if there is an owner that wants to sue the HOA and there are other owners that are listed in the suit or asked to do deposition, can the HOA attorney help guide the owners as to what to say during the deposition? So the HOA attorney represents the association. If a owner is deposing third-party individuals, typically those third parties should be getting their own advice. We don't represent those individual owners, so we might be able to talk with them and talk about facts. We would not be discussing typically what they should be saying or shouldn't be saying in a deposition because they're their own party. They need to get their own legal counsel as to what is best there. If the third party, my advice to them, if a third party owner was to reach out to us, say, I'm going to be deposed, I'd like to get your advice, I would say, I'm not your attorney. I would recommend you go and speak to get your own attorney to handle something like that. Last question that we have right now is how do you pick a mediator? So for collections and covenant enforcement, we have a couple mediators that we use a lot who we are very familiar with. We know they are well versed in HOA law, and so we try to use them as much as possible. If it is a bigger case, so if we're going to use someone at like JAMS or one of those type companies, we're going to look at some of the reported decisions that they have made. We're going to look at their background, what type of law they used to practice, if they were a judge, were they civil, criminal. Those are the types of things that we are looking at in choosing a mediator. Almost all mediators, especially private mediators, are formal attorneys. And so we have a pretty good idea of what their knowledge base is. And that's kind of the general way that we pick mediators. Arbitrators, again, we might not, we're going to be looking at their practice, what their industry specialty is, what other cases they have done, what other decisions they have made. But there's a bunch of information out on mediators and arbitrators that we can evaluate to try and make a determination of who we think is in the best case. Plus we're talking to other people in the industry. So not only just our litigators here, but also I'll call up someone at Mueller Graf or at a different firm, like, hey, have you ever mediated in front of this person? Or have you ever had an arbitration in front of this person and try and get their feel of what type of mediator they are, what type of arbitrator they are. That's typically what we're looking at. All right, I think we are at the end of our hour. Thank you guys so much for coming. If you have any questions, feel free to email me, jsmith@altitude.law. Thank you again for taking this hour out of your day. Take care. Bye.